Thanks, Mac, and thank you for putting this panel together with everybody. It's been great to hear everybody's views and insights on how to manage this crisis. I am a commercial litigation attorney for the MAQ Law Group. We have offices throughout the state of Florida, in Fort Lauderdale and in the Bay Area. And, you know, with the crisis going on, there's been administrative orders issued by the Supreme Court that essentially have shut down all but essential court proceedings. And so a lot of people ask me, you know, do you have anything to do while the courts have been closed? And the answer is yes. We've been tremendously busy with our clients' consultations, principally with three issues. And the first thing a number of panelists have touched on today, that's the SBA loan eligibility and compliance. Everyone wants to know what funding is going to be available to them, what the criteria for those programs are. And you've got some great resources on this panel for that. The only thing I would add to what's been said already on those programs is go into these loans keeping the compliance piece in mind. With the PPP loans, a tremendous benefit of those is if we comply with the conditions of the PPP program, that those loans are forgivable, provided we properly document payroll and the funds usage coming from those loan proceeds. And if you use a automated payroll service like ADP, they have great programs in place for documenting and PPP compliance. If you're doing this on your own and banking on the loan forgiveness later on, consult with an attorney or your accountant at the onset before you spend these proceeds, and make sure that you're properly documenting those so that when you go and apply for forgiveness, you've got all your ducks in a row. The other loan category, the EIDL program, we're getting questions about. Those are not forgivable loans, but they're very favorable terms over long-term direct from the SBA. And that's another option for independent contractors, people who don't have employees on payroll, that the government is still offering favorable loan terms under that program to assist with disaster relief. And so we've gotten some inquiries about that. Outside of those areas, there's the second wave of coronavirus relief that was passed before the CARES Act that created these loan programs was directed towards employees, and that was the Families First Coronavirus Relief Act that created two categories of benefits: emergency paid sick leave and an expanded FMLA benefit. The emergency paid sick leave applies to, both these categories apply to all employers, not just those with under 50 employees, which is typically what the FMLA applies to. So it's of concern to a lot of small business owners, team owners, people who have, you know, maybe only 4 or 5 employees under payroll, but suddenly have to be concerned with an area of compliance that they never had to worry about before. The paid sick leave portion, it has the broader number of categories. This is where if someone comes down with coronavirus, has to quarantine because of a government order that won't allow them to go into work, this provides for 2 weeks of paid sick leave, provided that the employee certifies to their employer that they have proper documentation, and they're eligible, if they're a full-time employee, to 80 hours of paid sick leave at their full rate of pay. And so there's a few exceptions and accommodations for smaller businesses, but this is an area, if they fall into one of those categories, that you can't take for granted. Well, we're a small company, or we don't provide, we're not covered under the FMLA. This employees may make claims, and there's some severe penalties for denial of those claims or retaliatory action against employees who make those claims. So it's important to know that that's going on. The expanded FMLA creates a new category under the Family Medical Leave Act for employees who have to shut down and have to stay home to watch kids because of closures due to the coronavirus crisis. So that provides for a 2/3 pay to any of those employees over the entire term of qualifying FMLA leave. And again, very little documentation required for that. It's the same certification process that applies under the conventional FMLA. Now, the upside of both of those programs, the paid sick leave and the FMLA program, is that employers will be reimbursed any amounts that they have to pay out in paid leave to those employees in the form of tax credits against their payroll taxes in the following quarter. And if those expenses are more than their payroll taxes over the quarter, it's a reimbursable expense, meaning they'll get a check for the overage. Now, for anyone on the panel who's an independent contractor, who's self-employed and isn't concerned about this, there's still a benefit for you in the form of tax credits that are created under the FFCRA. If you have a qualifying condition that otherwise you would go to your employer and get leave under one of these programs because you can't work due to coronavirus or due to having to care for your kid, your income earning capacity has been cut, you're still eligible for those tax credits as if you had been paid directly. So you're not going to get a check from your employer, obviously, but if you can certify that you have a condition that would have qualified you for those tax credits, you can still get up to $10,000 in self-employment tax credit for that quarter as a result of one of those qualifying leaves. So that's a benefit to a lot of small business employers. The third category that we're getting calls on is just what I would consider general commercial litigation inquiries, people whose contracts and landlords, mortgage holders they're asking, what can I do? My revenue stream has dried up entirely, and I still have these obligations to pay. They want us to look at their contract and see if there's an out, if there's a loophole, and by and large, the letter of those contracts and deals doesn't say if something goes wrong, you don't have to pay. But the way we're approaching those situations is by distinguishing between what's the letter of the law, what does the contract say, and what's the practical reality when you've had a working relationship with a client or a vendor for so long. Everyone knows what the situation is that's going on right now, and rather than sending a demand letter, a harsh legal position, it's important that we reach out and try to be problem solvers in these situations and say, hey, look, we know this is what's going on. This is going to be over someday, and you're either going to have a lawsuit or you're going to have a relationship that can continue to be productive. And with that approach, we've been able to resolve a number of these issues and be constructive in resolving disputes. So our contact information will be on the website as well. Encourage you to reach out for a consultation if you've got any of those issues in those categories, or any questions about how the law may impact you in this crisis. And thanks again, Mac.